A federal district court just ruled that the IRS broke the law about 43,000 times when it shared taxpayer information, especially addresses, with ICE, and that that's a violation of Section 6103 of the Internal Revenue Code, which provides for confidentiality of taxpayer information. So the question becomes, so what? What happens when a government agency, the IRS, goes ahead and shares information with another government agency and it doesn't meet the requirements to disclose that information? So my name is Brian Winrow. I'm a tax attorney and former prosecutor. And what I'm going to do is I'm going to walk you through and talk about the possible sanctions available. Now, that's going to include things such as criminal sanctions and civil sanctions, administrative sanctions, and then I'm also going to talk about, well, what happens to the employees who shared that information if they were told by the IRS to share that information. By their supervisors, they were told that they had to share that information. So we're going to walk through this process and we're going to see what the possible sanctions would be. Now, just because the court went ahead and found that the IRS broke the law, first off, we need to recognize that that is being appealed. But secondly, we also have to recognize that that's not under a criminal or even a civil complaint right now. So what would have to happen is an investigation would have to occur, and then it would be eventually brought to the Department of Justice. So we'll walk through that process as well. So let's go ahead and get started, and let's talk about what Section 6103 is, and then we'll get into what the different possible sanctions are for the employees and supervisors who disclose that information. All right, so when we're looking at this possible violation, what happens is the first thing is it has to be established that there is a violation under IRC 6103. Now, that's what the court is saying, that there would be a violation of this. So what happens under 6103 is that is a confidentiality component in the Internal Revenue Code that prevents the IRS from just disclosing information. And this is very strictly construed. I mean, this is a very important and strict confidentiality requirement. The reason being, our tax system is based upon making sure that people are voluntarily completing their taxes, so they have that right to be able to complete the taxes without the fear of their information being unduly shared with other individuals out there or other agencies out there. So under 6103, the IRS has to meet several requirements if it wants to go ahead and share that information. So one of the first things is it has to share that information only with officers in a qualifying investigation. So there has to be a qualifying investigation. It's the first requirement. Another requirement is there has to be a specific statutory justification for sharing that information. And then the third one, and this was one that the court kind of really hit on, was there has to go through address matching. So what should have happened is the IRS would go through and it would look at what the addresses were that ICE is sending, and then it has to make sure those addresses match before the IRS would go ahead and share any information. It's not intended for another agency such as ICE or any other agency to go through and to then say, hey, I want the address as the last known address of these taxpayers. They have to provide that address first, and the IRS then goes through and makes sure that it actually matches the addresses that they have. So there's that address matching requirement. Now, once it is determined that a 6103 violation occurred, we need to understand, well, what are the possible sanctions out there? And there are both criminal and civil sanctions. So when we're looking under the criminal sanctions, you can see Section 7213 of the IRC, the Internal Revenue Code. And what happens is it's going to cover willful, unauthorized disclosures. Now, this happens at the individual employee level. So the federal employees that would be disclosing that information would be the individuals that are going to be subject to criminal sanctions should the Department of Justice elect to go ahead and pursue criminal sanctions against those employees. And now the criminal sanction, this is a felony, so it's punishable by up to 5 years in imprisonment as well as fines. And then it is mandatory dismissal as well. So that's what you're looking at from the criminal sanction portion. Now it's important to understand it has to be a willful violation. Now a willful violation is going to be an intentional violation of a known legal duty. Okay, so it's the intentional violation of a known legal duty that we're looking at. So that's what the Department of Justice would have to justify. Now, interesting, there really isn't any type of good soldier type of defense here. So even if the employee were to say, well, hey, I was told by my supervisors that I had to share that information. Look, at the question is, was there a known legal duty that you were violating? Now, that could also bring the supervisors into the criminal aspect, even if they didn't specifically share it, if they directed others to share that information. And then you can see the other one that we're going to look at is going to be the IRC 7431, but under 7431, that's the civil component. That's where you're going to have damages that the IRS can be held liable for. And you're looking at up to $1,000, so $1,000 per violation, or actual and punitive damages. So that's where it can start to get. Now, when you're looking at 43,000 violations, right, we're getting up to significant amounts of money. Now, I'm not going to go ahead and just do the math and say 1,000 times 43, so we have $43 million. I'm not doing that because what you're looking at are possible other factors that could influence things, so it's much more complicated than just doing the math on that. But it can be a significant judgment. But we'll talk about some of those possible adjustments on it as well. Well, let's go ahead and look a little bit further as we look at 7213. So let's look at who could potentially be prosecuted for the unauthorized disclosure of Section 6103. Now, it's important to note that in the current IRS case where the court said, hey, the IRS broke the law 43,000 times, this isn't a criminal case right now, right? So nobody is being charged at this point having violated this law. And if somebody were charged, there's a presumption of innocence unless and until they were proven guilty beyond a reasonable doubt. So there's still that entire process. They'd have the right to a fair defense. Nothing like that. So this isn't to say that a person has actually violated the law. This is if a person does violate a Section 6103 provision, what is a potential criminal liability associated with that? So not particularly this specific case, but in general. So the first one is the employee who discloses the information. So when an employee discloses the information under Section 6103 and they violated that duty, there was willful, then what's going to happen is they can be held criminally liable. So the person who actually disclosed that information. So again, it has to be intentional and knowledgeable disclosure that was unauthorized. The second one is going to be the supervisor who ordered it. So if they were told they had to do this, then that person can also be criminally prosecuted if it was willful. Again, you can see over there that it's the knowledge of the disclosure was unauthorized. The authorized part isn't necessarily, hey, my supervisor told me I could do it, because like I said, there isn't this type of defense that I was told to do it. It is whether you knew that there was a duty not to go ahead and share that information, and you made that voluntary decision to go ahead and share that information anyways. So, did you know the statute was there? Did you know that under the statute you could not share this information? And did you choose to share that information on your own, or even if you're instructed to do it by another person? All right, the other thing I wanted to make sure that we're clear on here is the IRS as an agency. So the IRS cannot be criminally prosecuted for it. This only applies to the individuals who share the information. Now on the IRS portion, that's where you start getting into the civil component of it. So let's go ahead and take a look at the civil aspect instead of just a criminal aspect. So if it's determined that the IRS did not have the authorization to share that information and that it did indeed violate the law, then what you're looking at is a potential penalties. You're looking at $1,000 per act plus actual damages plus punitive damages if it was willful or gross negligence, and then also the cost and attorney fees. So there are different things that would be associated with this when we're looking at what their actual damages could be or their actual financial responsibilities would be in this case. For example, it would determine whether the court went ahead and said this is 43,000 separate actions or whether this all falls under one action. So if it goes ahead and identifies it as 43,000 different violations, then all of a sudden you're looking at 43,000 times when you're looking at the $1,000 act per act and the actual damages, and it can really increase from that part. If they say it's going to be just one act, well, then that has the potential of significantly reducing the type of penalty that it's going to be. Another thing that would also come into this is that whether it is found to be willful or gross negligence, because that can impact it. So intent can also impact the potential exposure that the agency could have if it is found after everything's said and done that there is a violation of Section 6103. So what would happen if you're looking at a potential prosecution of a 6103 violation? So how would it originate? Well, the first thing is you're going to have the Taxpayer Inspector General of Tax Administration, sometimes called TIGTA or often called TIGTA. They're going to be the ones that are going to conduct an investigation. So they're kind of the auditors or overseeing the IRS to make sure that there's no type of violations that are occurring. So it would initiate with them. So that's where you would start out. Then what would happen is if they found that there should be some type of prosecution based upon this violation, what they would do is they would refer it over to the Department of Justice. And the Department of Justice would have to decide whether there's going to be sufficient information to go ahead and to bring the charges against any individual that shared that information. So that would be a decision that the Department of Justice would have to make to determine whether they want to go ahead and prosecute the case. So it's important to note, it's not the IRS that prosecutes the IRS. The IRS is TIGTA's kind of doing the investigation, but then the Department of Justice is the one that's going to do the actual prosecution. Now, the prosecution is going to be done by the U.S. Attorney. So that's where that's going to come from. After the Department of Justice decides, yes, there's sufficient information, it'll be prosecuted by a U.S. attorney, and then this is going to be held in a federal district court. Now, there's a lot of other practical things that we need to mention here. Again, nobody has been accused of any criminal wrongdoing. No individuals have been accused, so that hasn't occurred. Now, the other things that you'd have to look at would be if a person were accused, if TIGTA went through and found sufficient evidence and then it went to the Department of Justice, well, the Department of Justice would have to make sure that there's sufficient information. Because remember, anybody who's accused has the benefit of the doubt, right? They are considered innocent unless they are proven guilty. So they would have the right to be able to confront evidence against them and to put forth a defense to sit there and say, listen, I didn't actually violate the law. So the decision by the judge to say that the IRS broke the law 43,000 times has not said that anybody specifically has violated the law. Anything for these different types of prosecution cases would have to go through, and they'd have that right to their hearing just like any other person who's been accused of a crime. Hey, if this video was helpful in having you understand this 6103 and the possible implications for a violation when the IRS shares that information, well, I routinely break down different types of tax cases. I talk about taxpayer rights and all those different types of issues. I also have a full line-by-line 1040 series for those that are working on their taxes that want walkthroughs, as well as student information, so content on information for students that are also taking classes. So if any of that sounds helpful to you, go ahead and subscribe to my channel for reliable tax information. All right, thanks for watching.